So one of the questions which I have raised is who can file a public interest litigation in Supreme Court? Who is the real public? Okay. Now I have raised that online petition and I have suggested that every public interest litigation, Supreme Court has to either appoint an amicus and ask public to send their views to the amicus, which they did in the case of this digital arrest case. And in an earlier case, on High Court actually opened it as a part of the process and asked public to directly submit their views in a particular case. That was a long time back on cyber cafe regulations. Okay, so but what happens is many times a public interest litigation is discussed in Supreme Court. These 2-3 well-known lawyers will be there and they will discuss. At least now we have the streaming of proceedings. Therefore, we will be able to at least see what is happening. Otherwise, public really do not have a say in many of the public interest litigations. That needs to be changed. I think it is time now to start. Okay. Now, friends, good evening to all. I have here quite a few eminent legal professionals as well as people who are DPOs and from the industry. I invite all of you to actually express your views. This is a round table. So my role here is only to present the issues for discussion and let us have the views of all the people. So the basic idea of this particular session was because on 16th February, Supreme Court has taken 3 writ petitions. One filed by one Mr. Venkatesh Nayak, who is a well-known RTI activist. Second, filed by the Reporters Collective Trust. And third, filed by National Campaign for People's Right to Information. In these 3 petitions, the petitioners have been arguing on various sections. At least one of the petitioners, the Reporters Collective Trust, has actually prayed that the entire DPDPA Act as well as the rules is unconstitutional as per Articles 14, 19, 21 and it should be scrapped. The cases are being argued by eminent advocates. Vrunda Grover represents, I think, Venkatesh Nayak's case. Reporters Collective is represented by, I think, Prashant Manu Singhvi. And then Reporters Collective is from Prashant Bhushan and National Campaign is from Abhishek Manu Singhvi. So all well-known people. Now, petitioners actually pressed for a stay on February 16th, but Supreme Court did not grant the stay. Instead, they just issued a notice to the government and then fixed the next hearing date for 23rd March. And they have hinted that they will be having a constitution bench to hear the petitions. The reason for that perhaps is that some people have made reference to Justice Puttaswamy judgment and said that this act is not in accordance with Justice Puttaswamy judgment. Some people have said this act is not in accordance with other Supreme Court decisions, some Subhash Chandra and other things. So the CJI has thought that it is better that a bench which can be called a constitution bench can deal with this particular case. So because as it proceeds during the discussion, if issues about constitutional validity comes, then the bench has to have the necessary strength. Now, the Reporters Collective's petition is the one which actually is little strange because it asks for issue of a writ in the nature of a mandamus or any other appropriate writ declaring the whole of the Digital Personal Data Protection Act or the whole of the rules to be void, inoperative and unconstitutional. Many of the professionals whom I have been talking, They say, no, anyway, Supreme Court is not going to void the act, so why we need to worry? But the fact that there are a set of people who are demanding a removal of an act which has taken 7 years to develop, I think it is a show of a little bit of unhealthy practice to use the Supreme Court to change the decisions of the Parliament. Nobody has come up with an alternative of how then we will be able to protect whatever we wanted to do for protecting the privacy of individuals. We have been talking about privacy protection and the requirement, and now if this act is going to be annulled, then it will take another 5-6 years for another act to come. I don't know whether they have such an idea or just demand something in the sky so that at least they will get something shorter of that. In comparison, Venkatesh Naik's petition as well as the petition of the National Campaign are a little more conservative in the sense that they are only asking for the changes to be made to perhaps section 44.3, which is the RTI Act related amendment, and to some extent certain provisions of the section 17. But what is strange is that there have been objections on section 36 and section 33 also. I will show what exactly are those sections a little later before seeking the views of the people here. Now, this national campaign, I have not read the full petition, but I've heard a 45 minutes video of the person who is representing that particular organization, and more or less their contention is similar to that of Venkatesh Naik. Basically, they are saying that the rights of journalists are being taken away. Okay, so there is a demand by journalists saying that they should have been given some very special treatment which has not been given. Now, 44.3 amendment is what may be considered as one of the main grounds. And this section actually makes a change in one of the sections of the RTI Act, 81J. And it says that the PIO may reject any application on the grounds that the release of the information could affect the privacy of some individual. Say, when RTI Act 2005 came, there was no DPDPA Act. And even the section 43 capital A of IT Act was not there when this RTI Act 2005 came. So subsequent to this, today we are having a new act. And the world has also moved. The GDPR has come in 2018. The more than 140 countries have passed data protection laws. And globally, it is considered that this is a thing which is necessary for all democratic countries to have. So to argue that there was something in 2005 which was overridden now, I think we need to debate whether when a new act comes into being, and this new act did not come just like that, it was actually a parliamentary act. So if it makes some changes in the existing provisions, I think one has to look at it in a proper manner. The second aspect the people are talking of is by diluting this 81J, the journalists are being affected. They cannot perhaps try to build accountability to the government, bring out information about corrupt officials. There may not be proper social audit. These are some of the arguments which we find in the petitions. Then there is this section 17(2)(b), which gives exemption for research. However, some people are saying they should have specifically mentioned journalists. Journalists also undertake research, and that research may involve collection of personal information. But if it is research, the law actually provides for some provisions, exemptions. But the petitioners feel that no, it is not there. Unless there is a specific mention of the word journalist, we are not happy. So that is where I think there is a bit of a lack of understanding of what the Act talks of. And I think there is a need for a bit of awareness amongst these petitioners themselves to understand that whatever they are showing as a concern is actually unfounded. Now, Section 36 simply had said that the government has got the power to ask for some information either from the Data Protection Board or from the data fiduciaries. Now, we are talking of a regulator and a regulated entity, and the government says that there is an empowerment that government has the power to ask for information. Now, that information can be about the financial information, can be about the directors of the company, can be about something else connected with the administrative and governance of the company. It is not stated there that this particular power will be used to get personal information from all data fiduciaries. But the reporters have taken that stand that there is an unmitigated power for the government to ask for all kinds of personal information from all the data fiduciaries, and therefore it is a question of mass surveillance. I think that is again a wrong, reading of the Act. Then they say that journalists, therefore, if they want to do an investigative journalism, they have got whistleblowers, they have got informants, and now they say journalists will be considered as data fiduciaries, and they will be asked to reveal the information about their informants, and therefore there is a problem for them. And then, of course, if journalists or data fiduciaries, they feel 250 crores kind of, penalty is actually debilitating for them. So these are some of the objections they have raised. So with this background, if for the purpose of today's discussion, we want to focus on a few issues, I have tried to basically look at these 5 issues. And we will first exhaust our discussion on these 5 issues, and then we will use the time for other things. I have Mr. Limine, Mr. Ranganathan, then Deepa, and maybe others, academicians like Manoj, Dr. Manoj. There may be other people also, even Mr. Koshi, representing the DPOs, and then Ramesh himself is a DPO. So we have got both the academic people from law colleges as well as the practicing advocates and the industry people. I will present each of these issues, and they can perhaps respond at that particular point of time. We will try to use this 1 hour as well as possible. So the issues are, first is about Section 44.3. If 44.3, whatever amendments have been made, is not correct, then what is that they are objecting? Now, what they are objecting means that the PIO should be able to actually decide whether release of a certain information infringes any privacy rights, and in certain cases determine whether the harm in releasing the information outweighs the public good. See, these are certain things which are not executive functions. We cannot expect an official in a department to be capable of understanding whether a particular information is infringing the privacy and so on. Okay. In fact, we all know that in the Puttaswamy judgment, the Supreme Court itself said, I cannot define privacy. I will just say privacy can be this, privacy can be that. So what privacy can the PIO can determine? Okay, I will show you the exact section, then you will understand what is happening. So this is Section 8(1)(j), the full section that which says that notwithstanding anything contained in the Act, there shall be no obligation to give information to any citizen which relates to personal information. Earlier, this clause was there, the disclosure of which has no relationship to public activity or interest or would cause unwarranted invasion of privacy, which meant that all these things should be judged by the person who is actually giving the information, who is actually a departmental officer in most of the cases, and then the CPIO may be a little higher. Now, so this person has to stand in the position of a judge, and the RTI activist is claiming that there is no privacy invasion, but there is a possibility that there could be a violation, and now the department or the government office is also a data fiduciary. There can be, if they do not make use of any exemptions or legitimate use, a data fiduciary, even the government sector, is exposed to this 250 crores penalty only. So if we are confronting this PIO or the departmental official that this penalty may be applicable to you, provided you are careful to see that you work within the exemptions, within the legitimate use, and so on. So if this particular change is not made, this particular official is responsible to decide whether there is no relationship to any public activity, whether there is unwarranted invasion of privacy, and we don't know what is privacy at all. So that is the onerous responsibility which this act was imposing on the departmental officer. Now, at a time when there was no DPDPA, no 250 crores, it was different. But now with this penalty and other things, I think there is a need for these officials also to feel little concerned that they have a problem, and government has considered that and made these changes. But at the same time, there is section 8(2), which actually provides another means by which information can be sought. But there also there is a need for determining that public interest in disclosure outweighs the harm to be protected interests. See, now in such a situation is there, we can expect that the government official will take the safety first kind of a decision. He will refuse when there is a personal information. And it is for the RTI activists to actually go to the court and try to get it. Otherwise, how do we expect this departmental officer to discuss or argue with a Prashant Bhushan or somebody of that stature across the table and argue something is infringing privacy, something is not infringing privacy? I think we are putting too much of pressure on the RTI activists, on the PIO, if this particular exemptions were not given. This is my view. Maybe the others may add their view. They may agree or disagree with me on that. So this is one of the things which we will discuss. We will come back to the other three things later on. Now we will have the discussions about this section 44(3) amendment, whether it is diluting the right to freedom. Now the argument in this petition is that by diluting the RTI Act, we are actually diluting the provision of the right to information, which is part of right to freedom of expression, which is also part of right to freedom of press. Okay. So what we are discussing is whether this amendment which has been made actually makes it makes the section that 81J affect the constitutional validity of Article 19(2), and therefore the DPDPA itself is violating the Constitution. This is the issue. Yeah. Now we will start with any one of you who is ready to actually provide your views. Okay. Anybody who can come forward? Mr. Lemie, Mr. Ranganath, Dr. Manoj.
Yeah, sir. I'm Rangnath here. Good evening,
Yeah,
everyone.
yeah.
I'm traveling, maybe the bit of a disturbance. Sir,
Okay.
my view on 44.3 is there is a conflict between freedom of speech, what they are claiming, and right to privacy, Article 19 and Article 21. So now, given this situation, the challenge of 44 sub clause 3 is somewhere valid because the RTA activists are under the RTI law. The public has the right to know on the information of the, say, generally for government related people who are employed there. Generally,
No, no.
RTA is not
So
taking.
when this RTI activist asks for information, whose privacy are we talking of? Are we talking of the threat to the privacy of the government official, or
Government,
are we
majorly it
talking
is for
of,
government officials, sir.
no, 1 minute, are we also talking of, say, for example, some beneficiary scheme or something like that? There are lots of public who have got some benefits, and the RTI activist wants to have a list of all the beneficiaries, their names, their age, their gender, etc. Now, is that privacy is what we are concerned, or is it the privacy of the government official? What do you think?
Unfortunately, under RTI, it includes all whatever you told, sir. But
Yeah.
majorly it should be used for the government officials, government body basically to know. But yes, but the RTI itself is a wide enough to apply for anything. In fact, we had also applied many things. They came back and said that is not allowed to provide in the RTI Act. In fact,
Okay.
before this conflict itself, okay, going
Ah,
forward, I'm not sure how much it will benefit from them. So my view is the bench may take a view. Definitely, they may not scrap DPDPA because globally it is accepted and all the countries are going for the privacy laws. And it is one of the mandate to do business work globally. That is one part. And also the data is precious today. So considering that, my view is the bench may take a view to balance between RTI and DPDPA and come up with a verdict.
Now, my
And
question
I'll give it to
is,
others.
does RTI, this scrapping of or change, amending this 81J, does it mean that if it had been there, can the RTI activist ask for personal information of all the beneficiaries of a government scheme? Because many these petitioners have also said that we want to do social audit. Okay, there is no accountability for the government, so we want to do a social audit. Social audit essentially means who are the beneficiaries. Okay, now for that there is a CAG, perhaps it has to do the audit, but social audit, these journalists say it is my right to do social audit. So I need the information of the members of the public. Now, these members of the public are beneficiaries of a scheme, and the government department is the data fiduciary, and they are processing it either under consent or under legitimate use. So this government department is also obligated to these people just like any other members of the public as far as the consent is concerned. And
Right.
maybe in future the consent has to be that, of course, the legitimate use says that if in any other act, if or a legislative requirement, if it has to be released, it is permitted. Okay. Now,
Yeah.
second, as far as the government official is concerned, I have a small viewpoint. Okay. Now, in the okay, shall I complete my point? In
Yes, sir.
the
Yes, sir. Go on.
in the government officials, I have one point. In the private sector, we use a term called business contact address, okay, or business contact information. Business contact information is not necessarily the personal information. It is given for the purpose of doing business. Now, a person who says so and so is the secretary of such and such a department, this is actually similar to the business contact information. This is not necessary to be considered as personal information. Secondly, the official's position, most of the time it's a gazette notified position, and most of it is available in public domain. It is already made public. So release of information of an officer who has perhaps given some benefit, I don't know whether it is really prohibited under this privacy excuse. And therefore, if there is a corrupt official, The corrupt official cannot hold back the information about himself. He can say that the beneficiary's information I will not give, but he may not be able to give the information about the official. This is one school of thought. I want others to say anything about it. Deepa? Dr. Manoj?
Yes, sir. My understanding is that, sir, I hope you are able to hear me.
Yeah.
Yes, sir. See, the earlier unamended Section 8, Clause 1, Clause J, actually tried to balance the two conflicting interests. That is, one is transparency, another is privacy. Now, this DPDP Act, which brings amendment to this, and now amended Section Clause J, actually giving privacy over transparency. The earlier version balanced, now it is giving primacy to privacy. So the balance has tilted from collective interest to individual interest. I guess if you see the previous judgments of the Supreme Court in recent past, it is giving more importance to individual rights and individual freedom and liberties. So I feel the Supreme Court will uphold this amendment, giving emphasis on right to privacy.
No, say if this amendment is cancelled, okay, then
Yes.
the PIO has to stand in judgment of whether a release is infringing privacy or not. Am I correct?
Yes, yes.
Assume you
Definitely.
are the departmental officer, okay, yes. Some social this thing, okay. You are a under secretary or somebody of that stature, okay. Now, the request comes to you. Now, you have to have the ability to take a view on whether giving this information will be infringing on any privacy rights, whether this is the information which Parliament, if asked, it has to be given there. These are all issues which are of a in-depth legal or judicial evaluation, is it not?
Yes.
So, do you want the officer in charge to be a person of that judicial stature to take a decision when the Supreme Court itself did not define privacy? Now, tell me what is privacy in this particular situation? Is it only the name? Now, is it publicly made available? Now, is it voluntarily given by the public? All these things, the person has to take a view. Because if I can argue that it is publicly made available, then there is no restriction. Okay. Then if his judgment fails and he releases the information, and if the data principal files a case against the government, now who will be held responsible for that? Will it not amount to the negligence of the PIO in not being able to judge the privacy harm adequately?
No, absolutely agree with you, sir. When it comes to the abilities or the qualifications of the information officers is concerned, but if this amendment is not given effect, the almost research comes to stand.
No, there is a grievance redressal. The first thing is the government also should have a grievance redressal system, so that can be invoked. Then there is the DPP itself. And anyway, it goes directly to TDSAT and Supreme Court. So a dispute can be raised, and it is not necessarily under RTI Act. If the RTI officer says that I am not releasing this information because it conflicts with DPDPA, I don't know, you can even take that case as a dispute under DPDPA and take it further. So there is a judicial intervention possible even here. Is it not? Maybe you may say that it is a little more difficult. See, earlier I could argue with that officer and say that you have to give this information. Okay. Now he will say that, no, I will not give you, please go to the court. That is the only difference which I feel has happened. So it will not actually undermine all the rights of the RTI information seeker, but it will make his task a little more difficult, which is, of course, something which is a natural development. DPDPA was not there earlier. It is there now. There is a data principal who is watching why should my information be given away without proper, say, consent. So the balancing has to be done now on the rights of the data principal, which was not there earlier. See, earlier, the concept of privacy was only what the government person thought of. Now, what we are trying to balance is the right of the data principal. So, does it not make some adjustment required for this particular purpose?
Definitely, sir. It's a collateral damage worth taking.
Okay. Now, what about others?
Good evening, sir. I am Balu.
Yeah, Balu.
Sir, RT Act is about public money. If involved, then only the RT Act applicable. DPD is about information. That is for saving public money. This is saving personal information. So, RT Act, that should continue. Because public money, how they are spending, government or something, any NGO getting a public fund. Each citizen has a right to know how the amount is being spent. So, that should be retained. Because of this, when you protecting the information,
that is still retained only. See, RTI Act is not being annulled. What is being added is that the PIO, which is the government officer, may not have the need to sit in judgment. So he will refuse at his level. Then it has to be taken up at an appeal level. That is what is likely to happen. So RTI Act is not going away. Okay, yeah, it will be there. Information can be sought, but when the PIO refuses the information because it involves privacy, the dispute is on whether privacy is infringed or not. So that decision will not be that of that PIO, but of somebody superior. That is the way I read it.
Naavi sir, I have a different interpretation here.
Yeah.
Koshi here. See, 81J in the earlier RTI Act was very clear with respect to, let's say I infringe money out of government public fund and I purchase a car for myself. Now, to disclose the registration number of my car, which I purchased out of that money, can I claim it is my private information? Because I bought the car out of that embezzlement of fund, or I took as a kickback. Now, just because the registration of that car is in my personal name and I'm a government servant, so can I say that this is private to me? So I think there was a balance between...
How did the presumption of embezzlement came? If there is prima facie evidence that something like that has happened, it becomes a criminal case straight away. And under law enforcement itself, information can be released.
I agree. But 81J, if you read very carefully, was meant to give immunity to public by virtue of this aspect of me taking money and creating personal wealth. Now, there's a very thin line between proving whether this is personal or whether I got it from somewhere else. There are different forms of acts against bureaucrats and civilians to declare assets and things like that. I myself in the government, we've been declaring assets every quarterly in the army. Of course, it is I think once a year for public. So that is there. But however, in terms of 43A, I feel there is no violation per se. If you remember the grounds in which Puttaswamy was passed, there was a reasonable what shall I say? There was a clause which says those three pillars.
Reasonable exceptions were there. Privacy is subject to reasonable exceptions.
So if a 11-bench judge has a court has passed a judgment, 1,500 pages. So this act is a fallout of that, primarily, the Puttaswamy judgment that came out. So from that point of view, to claim that there is a violation on privacy on a constitutional point of view is not. In fact, this actually provides the essential teeth to ensure privacy to the individual. So from that standpoint, if you see, this act is ideal in terms of India. And unfortunate for us, the Sri Krishna Commission went on the economic front. If you read the Sri Krishna report, those 200 pages, it was more from a digital economy perspective. Privacy was one aspect of it. So the claim that yes, the Sri Krishna committee report didn't come out per se in the act is also not an argument that has any water to be heard by the Supreme Court. Yeah, this is my take.
Okay. Now, in case there are no other immediate comments on this, we can go to the subsequent issues and then come back if there are more comments on this. Is it okay?
Naavi sir,
Yeah.
here I just had a thoughts and suggestions on this, sir. I completely agree that the purpose of DPDPA and how we are all focusing on it, right? From a legal perspective, as he was indicating, Benoj was indicating, it is very clear. You take it even in Article 21 or Article 19, your rights are not absolute rights, right? That's a point number one. The second aspect, when we look at it here in this entire petition, I believe that there are 3-4 principles which are heavily being taking it, and positions when they are trying to build itself conveniently, we are taking the principles, right? What are that? Transparency, accountability, privacy. There is no specific definition for any of these principles now defined it, right? When it comes to an individual, or when it comes to an government, or when it comes to an department, as you rightly indicated, these are all very subjective and interpretative terms. Today, anybody, based on the position as well as on the circumstance basis, these are all interpreted. You taken from an constitutionally, all these cases, whatever, there are a different positions. There are, and the judicial precedents, and overall how this is developed is because of the interpretation where they try to work it out. Jurisprudence is yet to be evolved on this. We are not denying it. When I look at it in keeping that as the context, even today constitutional bench takes some views, assume that out, right? The past, what it has been taken, can be override by the current bench. It can be override down the line in some other bench or some other judicial forums. Okay. So if neutrally, when we are trying to look at it, 2-3 solutions or suggestions where I am trying to come out, or I've been thinking of it when I was going through the petition, but not completely in its entirety. What I am at least looking out is, definitely your 8 subclause 2 of the RTI Act has to be retained, because that gives you a comfortable proviso of a clarity to you, right? Which is one. That should have not been deleted, ideal scenario, okay? Because
No, 8.2 is not deleted. 8.2 is not deleted. 8.1J has been truncated.
Yeah, 8.1J, they would have kept it. It gives a more comfortable position, sir. One. Even in a DPDPA, when it comes that out, there are 2 provisions. The government becoming a data fiduciary, right? The current act given a provision that today, if you take a concern, assume that out today you are taking a scheme. Why we are deliberating? Where is your, your journalist rights, or your government is recalibrating? Can I share? Am I violating the privacy concern? The point is that today it is not a concern based governance have been built in any of the system. The government has been defined as a data fiduciary, but still government has not started the process of complying to your governance as mandated under your data fiduciary.
Companies also have not started.
That is to the extent I agree, sir. That is a different.
It has to be done now.
Sir, but when RTI Act has to come, when I'm correlating, I'm saying it is primarily applicable to your government and PSUs, right?
Correct.
Where am I saying why today we are worrying? What is that, impact will come? Is the PIO is accountable for 250 crore? Absolutely all is yes. If I'm talking about an accountability and indemnification and liability, the government officer is supposed to maintain the consent. The moment you start maintaining your consent as a principle, you start to drive whatever it is, even the legacy data, The government is obligated to roll out and concern today. They cannot go with your deemed concern. That is my first point of clarification, which is nowhere captured in your application. Okay, they ran. I kind of feel that out. They just taken it out as the urge. Journalist doesn't have the clarity, doesn't have. When the moment DPDPA given yours, the government will fall under the category as a significant data fiduciary. The moment they become as a significant data fiduciary, your process to be followed. Today, what they should have done, the moment of May 2018, 2027 kicks off, the government also comes in the category of data fiduciary. Any data which they are going to share it, whether it has been through an RTI application or through any individual, the respective data fiduciary is supposed to validate that. And then they take an accountability, whether as a company, what I try to do today, should I need to redact? Should I need to give the right to access? Right to deletion is there? Whatever it has to be built in, the entire privacy by design system has to be redefined. When you take a consent, I strongly believe if it is a public money or a benefit of the government, already your section 17 is giving that benefit of exemptions to them. The same way, when you build this a mechanism as a data fiduciary with all the controls and the obligation which is mandated under DPDPA, to the extent reasonably we can come out and we know who is accountable. Because you have a concern, you will tell Deepa, if there is an mechanism, you avail the benefit. Assume that out, I have availed the cylinder with the subsidy, right? Tomorrow, someone asks the data, the government comes with the budget. They keep declaring the government has given the scheme of so and so on so many people, so many region. They can absolutely give that because I am one of the beneficiary. If I would have availed, everyone has a right to raise this as a embezzlement or the concern, right? I
Okay.
probably look at it from a different lens of it. I know this is going to be evolving. A preliminary discussion. This is my thoughts, preliminary
Okay.
thoughts on
Now,
this.
before we go to the next discussion, I just want to keep one point with all of you. One, we are discussing about whether DPDPA 2023 violates the Constitution or not. We are not discussing about Puttaswamy judgment holding privacy as a fundamental right. But DPDPA 2023 has never said that I am protecting Puttaswamy's judgment. As it said, no. The preamble has very clearly said that the data principle has a right called right to protect his personal data. A new right has been recognized by DPDPA. Okay. And that is right to protect personal data, which is the right of the data principle. Now, privacy protection is a constitutional responsibility which is intact. DPDPA 2023 does not address that the privacy. That's why I never use privacy by design. I always use compliance by design. The reason is that we don't want to take on a responsibility which government said I'm not taking, I'm not defining. Otherwise, you remember the 2006 version of the Privacy Act, Personal Privacy Protection Act, it had a definition. Privacy means so and so. And this has to be protected by 1, 2, 3, 4. Now, this time, privacy is not defined. It says personal data means so and so, and personal data has to be protected by 1, 2, 3, 4. So the DPDPA Act has clearly restricted itself for protecting the right to protect personal data of a data principle. And in that way, I feel one cannot argue that it is in violation of the privacy as a fundamental right. That is why I have said in one of these things that don't judge DPDPA by what it does not profess to do. In fact, government also has said that I am just calling you data fiduciary, you determine. Okay. And otherwise, we have to be accountable to the data principle whose information gets released in an RTI application. Now, where will he go? Can he then the RTI activist, can he indemnify against that? He cannot. Okay. But so that is an issue which I feel needs to be addressed. That is part of the balancing, the new balancing which is required. The earlier balancing was something But now in the new context, a new balancing is required. Okay, so let us leave it at that for the time being, as I'm only trying to say that there is sufficient ground to say that there is the truncated 81J retains the RTI, except it removes the compulsion of the PIO to release information in certain cases. Of course, he may take, in every case, he may say there is a privacy, there is a privacy. Okay, that is something which in the context one has to argue. Okay, but if there is a need for public information being disclosed because of social audit, etc., definitely there is a possibility of a violation of privacy of a member of the public. Okay, now if we are talking about the name and address or name and identity of the official, I say that it is not personal data, it is an official's designation, which is public information. So we should treat it as something which can be released without affecting the DPDPA. So I think if this can be read down, say if the Supreme Court just reads down this provision and say that the names or the personal data of the official to the extent determining who is the decision maker, which is essential for corruption, etc. If that is not restricted, I think the concerns will be reasonably addressed.
So to add on to your view, what I believe, sir, when the journalist or anybody RTI activist receive the information also, they will be holding the position as a appropriate data processor. Even
Yes.
they are accountable to not to misuse in a way or communicate at a discretion what they have to do, right? One.
Yes.
The second aspect, as you rightly pointed out, today how Companies Act define the KMP's data designation, today the DPO, the grievance officer or a DPO, the details are in the public domain.
Correct.
The Act mandates, your ITA mandates. Similarly, if Deepa holding a position in a company or a government as in a certain position, it is a business information. They are not mandating Deepas to share her personal mobile number or her address. It is about the Deepa Lakshmi, which is in which location position, probably an IAS officer, and so location they have been done. That is how we are doing. How we address the two. I think
Correct.
I completely go with that out as a business information. And any cases which has been filed even today, it is been called out the name to get the momentum on the case. Otherwise, it is actually attached to the position and the designation of the particular organization and the government in companies as well. So I don't think so. It is a personal information.
Yeah. So that is one of the views. Now we will go to this exemption for research. The Act says that when personal data is required for research, archiving, and statistical purposes, then it is coming under the exemption. And of course, under Rule 16, it says that certain standards of protection has to be maintained, which is the protection is security as well as certain privacy principles. Now, the petitioners are arguing that this doesn't apply to what a journalist does. I feel that what journalist does is also research. Okay, if he collects information, it is fine, as long as he, when he uses it for arriving at some decision and for say report or something like that, he may or may not be required to divulge the information on in the report, just as journalists hold back the information about their informants. In certain cases, if the identity of the beneficiary of one of the persons involved in the reporting is to be held back, they can hold back. Today, you see that in many of the TV reports, you are masking the face of women or something like that. Why? There is some view about that, and the names are say masked in many cases. So there is a possibility that, except in cases where a journalist is trying to investigate and then perhaps come up with a report like the Heidenberg report kind of a thing, in other cases, I think the research option is available to journalists. I think they are raising a kind of bogey. Now, any views on this, whether research whether the work of a journalist, does it fall under the definition of research or not? Any views?
Sir, Manoj here.
Yeah.
From the academic point of view, if you ask me, what this journalist doesn't fit to be called as a research. It's just a fact finding. They just find the facts and twist it or sometimes state it as it is. So it's not a research. Research should culminate in finding a solution to the problem. So they're just collecting the fact and stating it to the world. So it
Now,
is
what
not
is the problem? What is the problem of a journalist in terms of privacy in such a situation?
Sorry, sir.
What is the problem of a journalist collecting personal information? If that is not research, let us say it is not research, therefore there is no exemption. Okay.
Yes.
So
Yes.
a journalist, let us say this happens in investigative journalism. Okay. An investigative journalist often violates basic law also. Am I correct?
True.
But and he can even be called upon by in a court. The victim can always say that you have violated the law, and it is the court which has to say that there was overriding public interest or something like that. So the risk of being hauled up for legal violation in the case of investigative journalism exists today with or without DPDPA.
Sorry, sir.
Am I
Yes.
correct?
Yes. Yes.
In case, in case investigative journalism is it not equivalent to the investigation done by a police officer?
It is not. A
Why,
law
sir?
enforcement officer is different. A journalist investigation is different. So he takes the risk. In most of the cases, they take the risk because they know that if it goes to the court, court will support them. Am I correct, Manoj?
Definitely, sir. For them, truth is the defense. So they definitely
Defense, correct.
they
Correct.
take stand.
Yeah. So
But-
I don't think the DPDPA has made any change in this structure.
No, it has not made, sir. It has just made it what is implied now expressed. That's it.
Yeah. And
No, I
research,
think,
if it comes to research, that's a different issue.
Naavi sir, the substantiation here is on the petition, because I read the complete petition. It says that journalists have to be provided these exemptions under 17(2)(b), which I feel is not required. If 81J comes back in the Act, in the RTI Act, and this gets abrogated here in the DPDP law, then the journalists have their own freedom to do investigative journalism under that clause. 81J, Deepa may substantiate me. However, to seek journalist as a researcher under provisions and exemptions of 17(2)(b) is not a valid ground.
Okay.
I have read the complete petition.
Okay. Now, who is a journalist? Is there a definition of a journalist? For this particular purpose, now if you say journalist is given some kind of an exemption because they quote GDPR and other things. Now, how do we define a journalist? Will a journalist be one who is registered with a publication or he is registered with a government authority? What about social media people? Okay, are we not journalists? Because we are also passing on news on this thing. There are YouTubers. Now, are they not journalists? How do we sort this out in the new social media environment, where if you want to give some benefit to a category of people called journalists, how will you segregate a blogger or somebody and say that you are not a journalist? Is it not difficult?
Sir, my view on this, indeed, it is very much difficult because there is no registry or authority who classify or registers a person as a journalist.
Yes.
Like today, social media channels are coming. They are not registered anywhere.
Yes.
Like unless the printed media or TV channels, there are so many mushroom TV channels based on social media.
Yeah.
So maybe this will lead to another bigger question to identify who is a journalist.
Correct.
Now, coming to the
tell me. Yeah.
No, coming to the research part, as one of the academicians said, this may not be qualifying as a full-fledged research.
Okay.
What the journalist will do. It is a fact finding.
Okay.
What journalists do will be a fact finding. It won't qualify completely to be a research, but that fact finding, what they find and what they present, should be the same as per ethics of journalism. But unfortunately, we see it is not, and they run defamation cases. Any channel, if we see, at least 200 cases will be running against them. So this is the given fact at this moment, sir.
Okay.
Sir,
So that is about
just
yeah.
one point I will make, which may substantiate in Supreme Court while arguing. The thing is, when this issue was raised in Constituent Assembly debate, that the journalists should be given, or freedom press should be given a separate right, Ambedkar said no, they don't have any special right. It's part and parcel of Article 19(1)(a). Whatever citizens have, the journalists have. So they don't have any special right.
Okay, they are now claiming a special right under this petition, actually.
Yes.
Yeah. Okay.
So from day one, they are claiming themselves as a fourth pillar, where there is only three pillars: legislature, judiciary, and government. So yeah, given that situation, it may be difficult to tag them as a journalist, like as you said, a blogger or a YouTuber or a social media news channel. So how do we classify them? That there may be some mechanism or identity.
But if you remember, under the intermediary guidelines of ITA 2000 sometime back, the government had proposed, and it still remains, a self-regulatory body for social media intermediaries, and they were asked to register with the ministry. In fact, I have submitted my registration, because Naavi.org, I am giving some information which can be called news. FDPPA also, we said we will register. We sent out some one form they had given. They have not taken any action, but they had introduced a system of registration of digital media, and of course it did not succeed. In fact, long time back, when Kapil Sibal was the Human Resources Minister, he had introduced, suggested a system like this. That time also people opposed, saying that why should there be registration? There is press council, there is publications which are registered under the Registered Newspaper Society or whatever is that, and whoever is employed there automatically becomes a journalist. So now the social media situation is totally different, and unless we have a system of defining who is a journalist, it is not feasible to give anything special. And Manoj, thank you for pointing out that in the time of the Constituent Assembly itself, it was reached. Yeah.
Journalist is not a special. Journalist also to undergo all the formalities. So we not have a special. Police is invested in power, legal power. That is journalist has to undergo all the formalities. Otherwise, because of journalist action, more number of crimes happened. So when diluting the personal information, murder, everything we can say.
So we will go to the next one, because time as always is running out.
Sir, one quick question.
Yeah.
Do we know what is the view of the Press Club of India or PTI, the entities of the journalists here?
See, this reporters collective is a representative of most of these things, so you can take that as their view. Nobody wants restriction. Okay. Now, if they want, they let them give it out now. But the reporters collective, and there was also something called Reporters Guild or something like that. That also had opposed DPDPA earlier, and their views will be similar. Okay.
But again, it's only one section of the journalists, right, who are part of this reporters.
Say, there is no mention of journalists. Say, in fact, the Act does not specify SME, doesn't specify doctors, doesn't talk of lawyers, doesn't talk of chartered accountants, doesn't talk of journalists, doesn't talk of educationists. It does not specifically exempt a category of any particular profession. Though that power is still there within the Act. Sometime tomorrow they may decide to do it. But right now, they have been neutral. Okay, they have not stated any profession. They have not given any economic criteria like turnover less than so much and other things. They have left it to the purpose. If data is being processed for a particular purpose, it is determined as acceptable or not acceptable. So that's all. So whether it is a journalist or a doctor also will do research from medical data. So Research may be something which several people may do, but it is equally applicable to all of them. Okay, that is how this act has approached. It has not tried to identify specific sections of the society and say that there will be exemptions. So they need not perhaps make an exception of one category called journalists. Otherwise, how do you prevent, say, advocates, chartered accountants? Now you have to give them exemption also, no? Everybody has got some social functions to carry out. Okay. Now we'll come. Yeah.
Even advocates also comes under this, is it?
There is no exemption.
I am approaching the advocate with my purpose. I am giving information. Advocate also.
There is a separate Advocates Act under which there is a privileged information between the client and the advocate. That is different. Okay. But if the advocate collects personal information of a third party, he is also a data fiduciary. Okay. Suppose on behalf of the client, you want to do a research. Let us say, as an advocate, before you take the case, you want to do a research. You have a global detective agency or somebody appointed and try to get information. That does come under DPDPA. Okay? Yeah. Now, the next one, very briefly, is the power to call for information. This section 36 says, central government may, for the purposes of this act, not for anything else, require the board, which is the Data Protection Board, and any data fiduciary or intermediary to furnish such information as it may call for. This is all the one-line provision of section 36. Now, where is anything here to say this is giving excessive power or it enables mass surveillance, and just because of the section 36, the entire act has to be voided? I don't know. And if the government cannot seek information of this nature, what about the RBI asking for information from banks and SEBI, TRA and others? So I don't know why they have raised this innocuous section 36 as if it is a main section. Any viewpoint on this? Is it so damaging here? This is a section, actually. This is the actual section. Does it indicate there is something the government is usurping powers to call for any kind of information? Basically, they are saying personal information. They say a journalist may be asked to reveal the information about his informer. Is there anything here to say that such things is possible, or is it a figment of imagination?
Sir, my thoughts on two sides here, sir. Okay.
Yeah.
If we always look at it in a right spirit, the government is the supreme sovereign, and they have the accountability as per the constitution as a state to protect the citizens or every individuals of the country. Okay, irrespective of it. Today, assume that out. I'm just giving hypothetical situation. There is nothing. The war is happening. The government believes that out. There are some of the organizations which are colluded. They need certain data. The government has that is the purpose of the government, right? The government should have the right to seek, and if they seek the data within 48 hours or 72 hours on the emergency, they are supposed to obligated to give that out. I don't want to name the X or Y, the nature of it. It can be your social media or any nature of an companies, right? App developing company or whatever information. This is for the protection of the national interest and the public interest in true sense. If the authorities, the politician plays the game to get for the some other purpose, right? It is an individual motive. In a generic scenario, assume that out. If it is the motive on the which is beyond the lawful manner, somebody is acting, which can be 25%. The original lawful purpose and the real intention for the object of the constitution of the country, the government exercise for 75%. I think we need to go with which is the majority of it. It's always a double-edged sword, sir. So how we are going to exercise the right? I think we should enable the central government to do that out. Otherwise, if tomorrow the central government doesn't have the power, RBI will not able to resolve an issue, or SEBI, which is also an supplementary, the bodies which has been working under it, may not able to take any action. Today, someone want to get that out. We all know that out, Nira Nadia, all these cases happen. Some of the tapping, someone has to be recorded and it has to be shared. It has to be shared. That is how they
Yes.
can able to mitigate. So I think larger interest, I don't see a challenge in it. If Section 16 has been built, and I think what I've been absolutely looking at now is the overall implementation has not been taken care. Before that, they are trying to test it out. If you look into
Correct.
the Section 16, it very clearly says that data should be used for lawful purpose and it is for the minimization is given. If the same principle applies to the government as a central government data fiduciary, it is applicable.
Correct. Correct.
Right?
And people have been asking about accountability. Actually, this power can be exercised by a designated officer of the Ministry of Information Technology.
Absolutely.
So accountability will be there. If he say uses it wrongly, it is like a police officer committing excesses kind of a thing that can be separately addressed. Okay.
Absolutely. So today, the person on the road traffic police is supposed to regulate. If he is taking a bribe and we are also giving, I think that cannot be avoided in a system. But I'm saying every government, you should mandate to have a DPO. DPO is the authorized person to raise the request, receive the data, and then ensure it is an accountability lies with the position who
Yeah.
is going to hold it. That is where we are
Correct.
all deliberating how we need to tag it to the
Yeah.
board or bring it out as an accountability concept.
So this
Naavi
is
sir,
actually
I
yeah.
was director UIDI. When the
Yeah.
Aadhaar Act got amended, we
Ah.
deliberately took the amendment to this Parliament of the PMLA Act. And then, when there was a linkage of Aadhaar done to the PAN card, we realized that there were 20 PAN cards to one Aadhaar. So the provisions of such nature are required. I just want to substantiate
Correct.
it what Deepa man said.
Yeah.
And
Yeah.
sir, you see, the Telecom Regulatory Act, Section 20, lawful interception, did exist from British era time.
From Telegraph
So,
Act times.
yeah, the lawful interception provisions did exist. And has anybody been misused by that? It has not been
So,
misused.
in fact, that is the reason why I have said that the petition itself is disproportionately, imagining things and asking for disproportionate remedies. Okay, but anyway, now let me quickly go into the last this thing, which is Section 33. People have been telling that penalties 250 crores has to be paid. Nobody seems to have understood that penalty is up to so and so. It can be from 0 to 250 crores. Nobody says that you have to put 250 crores in every other case. And also, there is all voluntary undertaking. So penalties cannot be considered as a reason that the act should be voided. In fact, GDPR has got thousands crores, 4% of the turnover. So it has got nothing. The international norm is much higher. So this is another criteria which we can say is of no consequence. So I think we have tried to address what I have highlighted as the principal objections which have been raised in these three petitions. Okay, that is 44, 3, 17, 2, and 36 and 33. Of course, this is a matter of such importance that we can have much more discussions and probably we will have. Okay, so FDPPI has just started this discussion. I hope there will be occasions for us to have physical meetings if possible and then carry it on further. Okay, so I think we have come to almost 8:15. If any specific comments or questions are still remaining, please take this next 2 or 3 minutes, then we will close it.
Yes, sir, one question from my side.
Yeah.
Like earlier, we had Section 43A, which was giving compensation to the person who had a wrongful loss.
Correct.
Now, for this DPDPA itself is extension of 43A, and it was pretty surprising. There is no compensation part for the individual who has lost money.
But
Of
don't
course,
forget,
43
Section 43, there is Section
Yes, sir.
43 of ITA 2000. Please use that.
I agree that 43 subclause A to G, H, whatever. But at the outset per se, the reasonable security practice, what they were telling, that itself is missing, and many people are what they are thinking is 43A means the civil cyber case damage what I can claim. Now, in the public view also, 43A is gone, then I don't have a compensation, then
No, no.
penalty
See,
will go to the.
our Uma Shankar case was on 43, not on 43
I
capital.
agree. I know. Our Uma Shankar case was 43 subclause G, and subsequent cases, what I'm telling.
No, subsequent cases, people thought of 43 capital A, but 43 never went away. Okay.
Yeah.
Diminishing the value of information residing in the computer was covered under ITA 2000. Now, what DPDPA framers have thought is, let us keep this DPDPA as an industry level legislation. We will have penalties for the industry. We are not going to give individual compensation under this act. If somebody has really suffered a loss on account of privacy invasion, let them go to ITA 2000 and proceed. I think this is how I read it. They didn't want to overlap the two and make DPB another adjudicator.
No, I understand. Only my 2 cents to this is when they said 43A is repealed, maybe somewhere there could have been a message. Still, it is for the individual, whoever had a wrongful loss, they can claim under 43.
Yes. Now, not only 43, Section 67C, Section 72A, they are all, and even perhaps Section 66E, they all relate to privacy in different ways in ITA 2000, which will continue. Only one aspect, which is the body corporate's responsibility for protecting sensitive personal information, that section has been sucked off and replaced with this act. Rest of the things in ITA 2000 which apply to personal information will remain.
Yes, I understand.
To add on to it, Ranganath, I think in principally, as you rightly pointed out, it is an awareness issue on it, right?
Correct.
And the 43A is applicable only building the accountability on the corporates earlier. Okay.
Correct. Actually, Deepa, 1 minute. Let me interrupt. Because why I'm asking this, because IT secretaries also doesn't understand. Still, I can claim under 43. I have to convince them with 2 hearings. If 43A goes, then I can still sue the company under Section 43. That is my bigger worry.
No, you no need to go to 43 also. I'll tell you that's where, it's an entire ecosystem has to get, awareness. It's a cultural change. The Section 43A, when it is there in original in IT Act, what we all, along with the rules 2011 or whatever the amended changes coming in, we all believe in it was restricting only to the private organization. That was the position we all challenged it. If you look at it in multiple white papers,
Correct.
That particular clause, rather than deliberating or adding the word as a government, they brought it out as a DPDPA act, absolutely to consider among the global changes or whatever we try to bring in due to the development of it. It is only the accountability and applicability of the accountability to whom. As an individual, today, this act will not give that out. You have suffered under this, you go under only IT Act. No. Today, you as a citizen, you are having impact under your e-commerce application. You can go under your e-commerce guideline. There is a grievance redressal mechanism as per the guidelines which got notified. You can go under your Consumer Act. Today, the Consumer Protection Act covers both your, offline or a digital issues, anything. There is no such classification. If still it is in a civil related, which is extended impact, you can go under any act applicable. So it gives you to have a wider spectrum, and you can go within multiple action under the different act, how you can position, develop your case. I feel that out. It is lack of I absolutely agree from an regulatory side or authority side, as a users or a individual who we know the remedy. It's been a very larger segment has been given to us. Which choice we need to choose, it is up to us.
Sir, 1 minute, sir.
I agree with you. In fact, we are filing consumer court also a couple of things and have orders in our favor. Yeah. What I was telling was when you said 43A was repealed, it's no more. There should be some pointers so that everyone was aware. Anyway, let us not continue.
I agree that, but it's not the law wise, So 43A never given any kind of a remedy at any point into individual.
Okay. Yeah, I get you.
You get my point. See, 43A never given and rights to individual. Even if there is anything goes under the 43A, the individual will get so much. It was imposing the penalty of your up to 5 crore to the corporates only, private organization. So in
Yes,
true
yes,
spirit,
yes.
we have to replace with that and move on. Yeah.
Yeah.
1 minute, sir. Last, as Mr. Raghunath told, actual victim is not at all getting any benefit. I have lost my information, went away. I am not getting anything.
Please claim under ITA 2000.
Yeah, but why you are collecting? You can give a share to me.
No. Data
No, no.
protection
Yeah.
board. No,
Naavi, sir.
from the person, from the intermediary, if you want to claim also, it has to be done under Information Technology Act.
Naavi, sir, in that case, why should I complain to the board? I'll go to
You
43
don't
or I go
have
to
to.
consumer court.
You don't have to. And consumer court also may refuse if evidence, everything has to be taken note of. Because whenever crime is involved, consumer court can say this is not part of my jurisdiction. Some consumer courts are giving these decisions, but the jurisdiction of consumer court is on service deficiency, not on happening of a hacking or something of that nature. It has to go to IT adjudicator, from IT adjudicator upwards up to High Court, Supreme Court. Okay.
Yes, sir. What Balu sir was telling was like because of a data breach, I have lost money. Let us assume
Correct.
that.
No, correct. That he has to go to ITA 2000 is what I am saying.
Correct. Why then he should complain to board?
He
Nobody
need
will
not complain to DPB. There is no mandate that public should complain to DPB. If you complain, or if a case is filed in, say, an adjudicator's office, I would advise adjudicator officer to report to Data Protection Board that please take action against an intermediary if it is warranted. So it is not the mandate of the data principal to file a case in the complaint in DPB. If he wants, he can do it. Otherwise, he need not.
Correct. Okay, sir.
Okay. Yeah. I think